Good afternoon and welcome everyone to today's webinar. It's held jointly between Kochhar Company and the EU Chambers of Commerce in India. Our webinar today is titled as Arbitration in the Post-COVID World, Charting the Path Ahead. I am Mr. Kiran Nakurwala and I am a Principal Associate with Kochhar Company at the Mumbai firm in their litigation and dispute resolution team. I request all the participants to place their questions for the panelists in the chat box which is mentioned. I now request Mr. Bharat of the EU Chambers of Commerce to give us the opening remarks to today's webinar. Thank you.
Thank you. Good afternoon, the distinguished panelists, ladies and gentlemen who are attending this afternoon. Thank you for joining us on behalf of the Council of EU Chambers of Commerce in India. A very, very warm welcome. The Council of EU Chambers of Commerce in India is, as the name suggests, a federation of chambers and other members who essentially are focused around the promotion of trade, commerce, business and industry between the European Union and India. However, as a part of our thought leadership program, we, besides things that are of interest only to EU and India, we do undertake programs that are of general interest to members across all the landscape and across various corners of industry and business. This webinar is a part of that overall program, an outreach program to come to our members and other attendees with programs that are of interest generally. So thank you all for joining us. I will first very briefly introduce the panelists and then make some opening remarks. We have with us Justice Rebello, a former judge of the Bombay High Court and the Chief Justice of Allahabad High Court, my hometown. So welcome, Justice Rebello. Mr. Vitre, Senior Counsel, Bombay High Court. Thank you very much for joining us, Mr. Vitre. My good friend Nilanjan, General Counsel of ICICI Bank for India and Southeast Asia. Thanks, Nilanjan, for joining us. And last but not the least, our hosts for this afternoon, Mr. Rajashri Chakravarti, who's a Senior Resident Partner of Kochhar Company at their Mumbai office, a full-service law firm. Thanks, Rajashri, for joining hands with us for bringing such an important program before our members and other attendees. I speak now both as a President of the Council of EU Chambers of Commerce and Industry, which is representing businesses, as well as a business person in my own right. The role of alternate dispute resolution in resolving commercial disputes, I don't think I need to get into the merits of that. All that I can say is that the way disputes are run in India, we are often the victims of it or the perpetrators of it, and that is what makes the situation so complex. And therefore, a mechanism that brings us together in a forum which is swift, which is efficient, which offers confidentiality, and is able to combine the nuances of law with the principles of commercial issues involved in a dispute, there could be no better way of doing it. In the post-COVID world, I think this is going to only increase in importance. There will be a backlog of disputes. A lot of disputes will arise from the COVID situation itself. And those may be a combination of law as well as matters of fact. And therefore, arbitration would have a very, very big role in making sure that those are disposed of swiftly. And some jurisprudence and some sense of balance and proportionality introduced in the dispensation of justice between two opposing parties. So without much ado, I look forward to this, not just as a host, but also as an attendee, because I could be a beneficiary of it. And that's the vested interest and agenda I have of being absolutely enthusiastic about joining this program and maybe asking a few questions as we go along. So over to you, panelists. Thank you for joining us, and all yours.
Thank you, Mr. Bharat. A very good afternoon to ladies and gentlemen. It's our privilege to partner with EU India Chambers and bring to you an interesting topic of arbitration in post-COVID world, charting the path ahead. Now, in the last months, I think this has entered the collective lexicon all across the world, and that is new normal. Now, this new normal is something which we all are experiencing on a basis, and All professionals across sectors are mulling over how the new normal is affecting their business and what is the way forward. So today, what we are going to of extreme importance in the commercial world, which is the arbitration, and which we all acknowledge as the preferred mode of dispute resolution, particularly when it comes to international transactions, and how the two pillars of arbitration, as we know, the party autonomy and flexibility, these issues would be taken to their limits. How the due process concerns would be addressed. In our experience as a full service law firm, we have come across in the last few months number of such issues where we had to advise clients on multiple such scenarios, be it the cross witnesses, the discovery of documents, and so on. So, without further wasting of any time, let me now turn to my distinguished panel, because I'm very sure that all of you are very keen to hear the panelists, because we have a wealth of experience available today for us to listen from their experience during the last few months and what they see as the state of affairs so far as arbitration is concerned in the coming days. So let me turn to Justice Rebello. Sir, to begin with, what do you think about the current trend of pending arbitrations? How have arbitrations been impacted given the COVID-19 pandemic?
Just today morning, I had a video conference on the matter which was pending before me, where parties, in fact, had earlier agreed to the dates to proceed with the matter. Today, the senior counsel representing a local body, a municipal corporation, flatly said that he can't go on with the cross-examination because he has instructions from the local body not to proceed with the cross-examination. So these are what is coming in the way of proceeding with the matters. But overall, I do not see, in fact, there should be any problem. Firstly, the matter of documents which you just mentioned. In international arbitration, if you have the red fern schedule, which is followed by everybody, parties sit all across the globe. Documents are set out in the red fern schedule. Parties apply for discovery. Parties then go on admitting existence of documents or whether they also agree with the contents. So the whole exercise is done by video conferencing much earlier to the actual sitting. So really speaking, these are things which should not really stand in the way of matters proceeding forward. But we do seem to be having problem with basically counsel been saying that they are not in a position. And the problem which I find over here is, frankly, let me be frank enough, thousands of documents are filed, most of them irrelevant, which are really not required for the final hearing in the matter. And then because everybody seems to be just photocopying the pages without examining whether those documents are relevant for the dispute or not. Thirdly, as is the general trend in India, sorry to say it, the person who is defending a position always seeks to delay the proceeding because that is to his advantage. Of course, forget the post-34 scenario, but this has not, in fact, gone away from the arbitration also. So, but with an effective arbitrator and an effective timetable, this can be managed, because under Section 19, as you know, under 19(3) of the Arbitration Conciliation Act, the parties can agree to a procedure, failing which the arbitrator himself can determine the procedure. So the arbitrator can, in fact, the tribunal, the sole arbitrator, or more than one arbitrator, they can enforce certain procedural directions, including, for example, going by video conferencing. But now, as the Supreme Court has, in its direction, said that cross-examination cannot go on without consent of the parties, That is a block insofar as 19.3 is concerned. That does not mean, of course, where there are genuine difficulties, matters should not be adjourned. I do see there are situations sometimes when parties don't have access to documents and it becomes difficult. But overall, what I feel is this arbitration by video is going to be, especially in the first appearances, meetings, framing of issues. Judges, arbitrators don't have to travel to a place, nor do lawyers have to travel to a place. These first two steps of the first meeting, framing of issues, discovery documents, all this aspect can be done by video conference. Even the parties are. So this, to an extent, will bring down costs of the arbitration also. So I'm hopeful post COVID-19, we are in a position to learn from these experiences, and also as we go on with arbitrations and learn the difficulties, possibly we'll learn other problems also, that it is not necessary to meet the tribunal to assemble together, but can, like some international arbitrations, proceed with one arbitrator in London, another arbitrator maybe in Australia, third arbitrator in India. This is something is not difficult, except that it requires a lot of work. Let me put it frankly, it requires a lot of work on the part of the counsel for both the parties to prepare their briefs, prepare their documentation, and then be prepared to argue the matter. These are the few thoughts I would like to share in the COVID-19 situation. Thank you.
Thank you, Justice Rebello. I think you make a number of and valid points. One, of course, is the reduction of cost in post-COVID era with the use of technology. That is a very valid point. But equally important is, I think, the timeliness and uh, disposal of matters. So, with that, let me turn to Freddie. Freddie, what are your thoughts expediting the process of the pending arbitrations? Rebello seem to think that sometimes councils can be probably at fault. So, what are your thoughts?
No, I think frankly this COVID-19 situation can well result in a very positive impact on arbitrations, and I say so for a variety of reasons. Because when one says, as Justice Rivello seems to feel, that some counsel are reluctant to carry on, I think it's basically the paraphernalia, which is the lack of availability of the necessary equipment that sometimes retards or sometimes dissuades a counsel or any party from carrying on. Because as far as I can see, I think we must distinguish at various stages, as Justice Ribello rightly said, various stages of the arbitration. The initial stages, where the stages of giving directions, where the stages of getting parties together, filing pleadings, etc. Those are the stages which are eminently suitable for being conducted on video and by virtual on a virtual platform. So also the end stage. Once you finish the cross-examination, the examination of witnesses, etc., the end stage where you are at the stage of arguments. I think arguments also are very eminently suitable for being conducted on a virtual platform. It is the in-between stage, namely the stage of recording evidence, that has its own peculiarities and may pose its own problems. But I think the first need for expediting anything that one has to do in a virtual world is to digitalize the record. Because without digitalization of the record, it is going to be impossible for parties to proceed. I mean, one can have physical documents, and there can be a hybrid system of physical documents and digitalized documents. But I think it's necessary as a first step that the entire record must be digitalized in some manner of a uniform system. I mean, it can't be of course, like in physical, you must have a pagination which is uniform, etc. But even the format of the digitized version. I mean, I have been conducting arbitrations myself as an arbitrator. I find hearings go very smoothly when everybody is on the same page, so to speak. Either you have an instant communication by way of emails, or you have various storage facilities now on the cloud, etc., where all this is done. But I think as a first step for expedition, and particularly in India, because we are not as used to as the international arbitration world to this sort of virtual platforms. So I think particularly in India, this entire process of some sort of a uniformity in the entire digitalization of the record is an absolute essential to my mind before we can proceed further. And I think it is not going to be an excuse for somebody to say that, oh, sorry, I don't have the equipment. I mean, look at it how things have evolved. There was a time when the Evidence Act only dealt, for example, with handwritten documents. Then they introduced typewriters, and they said, and there was an amendment to the Evidence Act, and they said typewriters or typewritten documents will also now be regarded as documents. So things have evolved. At that stage, could somebody have come and said, or a lawyer come and said, I'm sorry, I don't have a typewriter. I will rely on handwritten documents. Surely the court would have said no. So as it evolves, today it may not be possible for a person to come and say, I'm sorry, I don't have the necessary equipment. It has become a necessity now if you want to practice, if you want to carry on with these arbitrations. I think we are reaching a stage where it's a necessity now to have all this necessary paraphernalia, necessary equipment, which facilitates this arbitration. So to that extent, as Justice Ribello said, it may reduce costs. It may, of course, evidence and recording of evidence stands on a slightly different footing. That may be that may be a sort of topic of a slightly different subject. But in so far as, let us say, the bulk of arbitration is concerned, and the initial and the end stages of arbitration, including finally the award, I think it lends itself really to a virtual platform and proceedings on a virtual platform.
Sure, Freddie. I mean, I think what I take from what you mentioned just now is that if only we can address the issue of technology and sort out glitches, so to speak, then I think this is a wonderful platform or wonderful way of conducting arbitration. That's what you were saying. So to that, let me ask you a question. Do you think, and this is actually true for the new arbitration matters, do you think something like a case management conference between parties prior to the initiation of the whole proceeding, that would help to iron out all these platform issues and uniformity issues?
I think undoubtedly it would. Undoubtedly. And I mean, it's also an existing practice, at least I'm sure Justice Ribello does it. I certainly do it as an arbitrator, that you do have initial meetings where you sort out the entire process. You fix timelines and you expect parties to adhere to these timelines. So this case management thing is not unique in that sense to conducting arbitrations on the net or virtually. It would be just transferring what is the case management system in a physical world into a virtual world. So to that extent, yes, case management would certainly help, except that the directions would obviously now be a little different, because your directions would then maybe it might include directions in such minute matters as what is going to be your font, what is going to be your type, or how many each affidavit may have a certain restricted number of pages. You may give directions for filing in zip files. You may give directions for filing with only bookmark pages, etc. So the nature of the directions may change. But I think this case management system at the start of the proceeding would be a very healthy way of expediting matters ultimately down the line as the arbitration progresses.
Sure. So with that, let me turn to Nilanjan. Nilanjan, someone who is very closely associated with the financial services sector and someone who is on the client side of it. You have two questions. Firstly, of course, what are your thoughts on expediting the process? Well, you heard Justice Ribello, you heard Mr. Divitri. But in addition to your thoughts on expediting, do you think that arbitration as a process is really beneficial for the BFSI sector?
Yeah, good afternoon, Justice Ribello. Good afternoon, Mr. Dimitriv, Rajshri, Mr. Bharat, and thank you for allowing me to be a part of this panel. And by itself is very elating to be a part of this panel. Thank you. As you rightly said, look, insofar as the BFSI is concerned, there are two sort of aspects to it. One is that you will see that not many banks use arbitration very, very commonly. arbitration is common in non-banks, and I think the reason I would say is one of the primary drivers was that banks have access to a special tribunal through a DRT, and therefore, we have a special tribunal for resolving matters relating to recovery, whereas the non-banks do not have that. So it's one of the alternate ways to do that. Having said that, I think, I mean, sort of just reacting first to the fact that BFSI and arbitration. If you really see, while this is the position maybe in India, if you really see globally, and if you see emerging markets or developed markets rather, like London, where there is a lot of financial litigation, you will see arbitration is being used very effectively, and I think for very good reason. And I'll give you one example, that if you have very complex financial contracts, one of it being, let's say, a derivative contract, to try and sort of interpret that, to interpret what would be the way the derivative contract should be sort of looked at and interpreted. Admittedly, you need people who have very specialized skills. While I think it'll be unfair to expect a judge who's got dealing with a very wide range of issues to try and get in and quickly. I'm sure a judge can do that very effectively, but to also be able to do that expeditiously, it may not be reasonable to expect. Therefore, arbitration becomes very useful, because then you can actually choose an arbitrator who has the necessary skills, and the person comes in and interprets. And these contracts are important from the country perspective, because if you have wrong judgments and wrong interpretations, your country becomes a very low-rated country. It becomes a country where there is high risk for the counterparty. So in such kind of contract, whether it is large lending contracts, derivative contracts, very structured contracts, arbitration is very, very should be the way to go, is my view. Insofar as I think the COVID scenario, which I think Justice Robello and Mr. Dimitrov has already covered most of it, but as I would say as a client, that look, why does one get into arbitration? You get into arbitration because the flexibility, as you just mentioned, about the case management. You have the ability to really do case management the way you want to, and you're not really bound by stricter rules of the court. And therefore, this, and actually, if you really therefore look at it from the reactions globally, which has happened to the pandemic, if one was to look at what the Hong Kong Arbitration Tribunal has done, a Singapore Tribunal has done, a ICC has done, each of them have come out with guidelines for what is expected, what is the method in which guidances of how the procedure should be conducted, how the efficiency would build in, and stuff like that. Therefore, to me, once you are getting into an institutional arbitration, and an institutional arbitration which is receptive and which is nimble-footed, would react to these situations and is reacting to these situations very, very, I think they're looking at this as an opportunity, honestly. And because otherwise, as was mentioned, that case management is anyway a part of this arbitration. If you really look at it, all modern arbitration centers, centers for arbitration are already enabled electronically. So I don't think there is any challenge. I mean, they electronic filing, electronic hearing, and all of that. Of course, there are some limitations, as Justice Robello said. That how I was talking to one of my is that exactly that. How do you do a cross-examination? Because High Court has a rule about cross-examination. How do you don't want to show a document of what you want to show the other side beforehand. So you want to show him there, and you got to ask him about his reactions to it. So those are matters one has to sort of deal with. But I think otherwise what I'm trying to say is that, look, in institutional arbitration, this electronic readiness is already there. It was not being adopted earlier. It was earlier, sort of optional. I think that has become now mandatory. the adoption of that has become very high. I think, for councils, for arbitrators, it is much more convenient from time management. For clients, it is better for time management and therefore case management. So I think it's a great opportunity, and the opportunity, I think from a positive side, I see people are actually adopting to this very, very, as an opportunity. So that's what I would say, Rajshri.
Okay, thank you, Nilanjan. You mentioned one important part. I think that is going to lead me to the next question to Justice Rebello. You talked about the role of institutions and the international bodies that we are familiar with, be it SIAC, be it ICC or LCIA. Justice Rebello, I wanted to ask you one thing. Do you see any specific institutional rules coming up, or any new efforts being made by parties to the arbitration agreement to amend their existing terms, just so that the process is facilitated in the current circumstances?
See, for the present in India, more than 80% of the arbitrations are ad hoc arbitrations. They are not institutional arbitrations. There are very few institutions in India which presently have one based in Delhi, and Mumbai. We have just started the Mumbai's International MCI, but it is still trying to emerge. So therefore, looking at in the context of whether Singapore, Hong Kong, that is whether SIAC or ICC, may not be, for the moment at least, India is concerned, the exact scenario. See, I have been doing some ICC matters. That is totally different. The rule, they are long-standing institutions. They have their set procedure. They have their set rules. In India, they are still teething problems. Only now, because of the amendment to the Arbitration Act, that now institutions also been conferred the power of proceeding with arbitrations. So we will have to watch, in the sense, but having the experience of how international arbitration institutions are functioning, it will not be difficult. But the question still remains is whether parties are willing to go to institutional arbitration. Because most of the time the contracts in the contracts they do not provide for any institutional arbitration, rather for ad hoc arbitrations. So we have to see in that context. Now the rule, in Bombay, for example, we have the Indian Merchant Association. Then I mentioned the MCI, two institutions which have come up, but they are still struggling. The rules have been framed. I had been a party looking at the rules. Rules are based on international institutions. So insofar as the rules are concerned, the procedure is concerned, all that is based upon international rules of SIAC, Hong Kong, ICC, etc. So the best has been brought in, and so the rules are there. The question is whether parties, for example, MCA did try to get the government of Maharashtra to agree to institutional arbitration. To an extent, they had agreed, but I do not know what is going to happen what is happening now or in the future, because as government changes, person change, then the ideas change also. So institutional arbitration, yes, is required, but for the present, considering 80% of arbitrations are ad hoc arbitrations, there is no need, as I would say, to further strengthen. The need is that parties have confidence in approaching these institutions and try to make their contracts in tune with these, either adopting MCI, IIM in Mumbai or around. In Delhi, we have the ICA, Indian Council of Arbitration, which has been there for quite a long time, and which has got, of course, which has a substantial number of matters compared to the other two institutions. I do not know the experience in the rest of the country, but then basically we have the arbitration in Delhi, in Mumbai, to a certain extent in Bangalore, maybe Hyderabad, but the rest of the country, there's not much of arbitration. So it is focused basically on financial centers, And that's where the core arbitration institution must spring up. And so therefore amending, I do not see what purpose would be achieved by amending anything. The rules are there in existence. And as far as I'm concerned, to the extent, it's a question of people willing to go to them. That's what I would like to say.
Sure, sir. Freddie, would you think that this experience with 19 and what Justice Rebello mentioned, as we all know, that almost 80% of arbitration in India is ad hoc, and institutional action, unlike the Western world, it's not that prevalent. But do you think that it will change, the tide will turn going forward? Sorry, you need to unmute. Freddie, you need to unmute yourself.
I was just unmuted, I think. Can you hear me?
Yeah. Yes, please, go ahead.
No, I think going forward, frankly, I have very little, well, not very little, but I don't have as much experience of institutional arbitrations as I have of ad hoc arbitrations, because as Justice Rivero rightly said, the bulk of arbitrations in India at least are ad hoc, whereas maybe the few international arbitrations one has done have all been institutional arbitrations. But maybe one of the things, or a couple of the things that institutions in India might consider introducing into their rules, and maybe greater enforcement of existing rules, as Justice Rivero remarked. Things that would expedite arbitrations and enhance the client's experience, or the client's confidence in the arbitration process would be, if you have, for example, in many international arbitrations, you have this chess clock system, where time is divided between the two parties. You are allotted X amount of hours. How you divide the hours is up to you. If you want to use the bulk of the hours in an opening address, or you want to use the bulk of the hours for cross-examination or for closing submissions, or you prefer not to have closing submissions but have written arguments. If institutions get evolved in some form there, you might see arbitrations getting over in a quicker frame, in a quicker time frame, and which would, I think, assist the commercial world also, because essentially these arbitrations, of course, when one talks of the commercial world, I don't think you can exclude the small-time trader or the people who don't have very large claims. We all talk of international arbitrations, etc. But given the way our judicial system has become a little expensive and access to it has become a little more difficult for what you might call the common litigant, if you want to phrase it, or the ordinary litigant, it may well be that arbitration must now begin to cater also to these smaller claims. I mean, today, for example, if you have a small claim, and by small claim, I would, from my experience, even a claim of say 1 crore or 5 crores today would be regarded as small claim when you compare it to the costs of arbitration. So I think the institutions must have some method by which costs are reduced. One of them may be the fixation of time limits. The other, although it may sound as if it's contradictory because it would add to the cost, it may well be the system of verbatim recording. Personally, I am not in favor of verbatim recording, but almost everybody I speak to on the international circuit is gung-ho about this this verbatim recording of evidence, whereas we have a system where the witness answers, the arbitrator records it. We have very competent people on the machine now who almost do it like a verbatim thing. But still, these are things which may enhance the confidence of the commercial world in arbitrations if institutions manage to do it, and if they can provide a uniform platform for the recording in a virtual world. Institutions, I think, should now make uniform systems. There's too much of ad hocism in the institutional arbitration, if you know what I mean. Each one has its own. If there is some element of uniformity, I think it would help a great deal.
Fair point. Fair point. I mean, while the need for a proper framework, but there is also the need for uniformity. Nilanjan, are you satisfied with the response of the institutions, or you also sense that a bit of lack of uniformity amongst institutions? In other words, how do you rate the institutional response ever since the the COVID pandemic? Are you satisfied?
Actually, I think, again, look, as Mr. Rebello said, that what I was alluding to is that we have the necessary framework, and we have, fair degree of, of course, may not be as many, but we have, the infrastructure available. What has been I think a problem, according to me, is a couple of problems. So one, that we spend very little, as been observed, that most of our arbitration is ad hoc. When you're doing an arbitration agreement, you do not spend any time in deciding what the procedure of the arbitration will be. All you decide is whether you'll have one arbitrator, two arbitrator, and where will be the seat of arbitration. You do not spend any time in deciding a procedure. What therefore happens is the arbitration, ad hocism in the ad hoc arbitration is as ad hoc as the word is, because then it decides, it depends on the arbitrators. Are we then becoming willy-nilly trying to, actually give away the benefits of arbitration? Being that, you can decide to do this expeditiously, have a simplified process, a process which is not does not have perversity in the process, and therefore you have a judgment quickly. But we tend to, and my personal view is, we tend to mimic this CPC. We tend to mimic what is happening in the court processes. Whether it is the documentation, it is the process it is run, the way it is done, we are doing all of that. And that we are so used to. What I was trying to allude to, Rajeshri, is that there was always, people don't like to adopt change. While those institutional arbitrations were being talked about, these processes, this infrastructure was kept in place, adoption, as I said, was very low. And I'm saying this is the opportunity for adoption. This is an opportunity where, you and I are locked down and, doing this call. Normally I would have expected to be in the same room, and you would have bought me a cup of tea, and we would have had a nice 5-star hotel where we will do this. But now we are doing it. So we will be doing the same arbitration now using technology. And I think this is what I was saying, that today this is the great opportunity to do this adoption. Has the adoption already happened? No, it is too early to say that. But I'm saying this is a great opportunity, and I'm pretty confident that we will be looking at this opportunity. In fact, I was looking at it. It is also sometimes one used to get used to the taste of good things. I'll give you an example. I read somewhere that the Stockholm, or one of those places, in the institutional arbitration, they have actually opened up their facility for ad hoc arbitration. They said, come and use our facilities. While, in normally you would have had to do it, you would struggle. They said, use it. Now, what would happen is that once clients get used to, the doing it more efficiently, adoption is going to be very high. So I urge that, if in India, similarly, our institutional arbitration, I know of many such places who have great facilities. They should open it up. They should let people, get into these and use their rules, use their facilities. Then I'd say, Rajeshri, the adoption is going to happen, and I'm pretty confident it will happen very, very well.
Lanjan, and I really the expression ad hocism in arbitration. Made a note of it. Use it sometimes. Now turn to some of the problems. I'll with Freddie. Freddie, if we parties, if there are problems in deciding on the of the arbitral tribunal, approach the court and sundry other purposes. As we all know, courts are only taking us which are urgent in courts. How do we address that scenario? Do you courts will consider of an arbitrator an urgent issue worth hearing? How do we deal with them? Sorry, you are muted. You need yourself.
I think that this notion that courts, yes, courts are hearing urgent matters. They started with a very restrictive sort of group of matters. It's now become a little more expansive in the sense that it's not just restricted to very urgent matters, because as things have evolved, as things have developed, People have adapted to the changing situations. The lockdowns have been relaxed, etc. So I think courts are sensitive to the need for expeditious disposal of arbitrations, and particularly the expeditious initiation of arbitrations. So I am not one of those who believes that a court would not find the time to appoint arbitrations. I think Section 11 applications are likely to be given preference. I believe in the Bombay High Court they have been given preference, and these applications are disposed of fairly quickly, because in the Bombay High Court at least we have situation where there is a specially assigned arbitration bench now, and arbitration matters move along at a brisk pace. It's a different matter. Maybe the end result may be opposite. Namely, Section 34 applications may have to wait in the queue during this COVID period. But I am reasonably confident that courts in India, and particularly in the commercial capital in Mumbai, courts are going to be sensitive and will give some priority. I'm reasonably confident that courts will accord some priority to this question of appointing arbitration, so that the arbitral process can commence now.
No, it's good to know that the Section 11 you're attention, and it's not that Section 11 held up. That's a very big sign. But Rebello,
Sorry, your voice is breaking.
what is the solution? Okay, can you hear me? My next question was to Bello. What's the way forward if one party does not agree to a virtual as a means to proceed? How do we cope with this? Won't it delay the whole adjudication if both parties are not engaged?
We are in a time of a COVID situation, a pandemic situation. We are not a normal situation. In normal situation, virtual hearing could go on without any problem. So even an arbitrator has to bear that in mind. But as I pointed out earlier, if you look at Section 19.3, 19.3 gives confers, it's either the parties who may agree to the procedure, or if the parties do not agree, the arbitrator can fix the procedure. And procedure, I would presume, also would include hearings. It will be a part of the process of the arbitration moving forward. So therefore, that is not a hindrance. Fixing the procedure and proceeding with arbitration is not a problem. There are sometimes, as I pointed out earlier, there are those who would like to delay, but then there are sometimes genuine problems of having access to documents. Now, I have been having some matters where parties have been continuously asking for time on the ground, that they are not able to access the offices to retrieve the documents. Yeah, some of them have difficulties that they say our parties are, some of our employees who are there are located in some other place and they cannot come. If they come, then they have to remain in quarantine for some 14 days or whatever it is, which every state has got its own problems. So these are practical difficulties in these times. If not for the COVID-19, the pandemic times, virtual hearing should not be a difficulty. As Freddie pointed out, yes, in the matter of evidence, there may be some difficulty. We have been hearing arguments, and the documents have been shown on mirror screen to us. So you don't have to really go through the entire. There's no even you don't have to open up your files, because the file is shown, the document is shown to you, and therefore it becomes very easy when the document is mirror screen. Of course, you must have an effective junior, a junior who really works up who's conversant with everything. But then this is the position that things can move. But as I said, this is a time of practical difficulties. So you can't look at every application by a council or party for deferment of the matter as an attempt to delay the proceedings. I can and do understand that there are problems which we have been seeing now. So many of the matters which parties earlier agreed to, they are asking for deferring for days for recording evidence or arguments. Because we have one matter where counsel who was supposed to be in Bombay are in Goa. Both the counsel on one side. Of course, they will be enjoying Goa's hospitality differently. But then they say we have no access to our files. Our notes are in Mumbai, our files are in Mumbai, and there's difficulty in even getting the files from Mumbai to Goa. So these are practical difficulties. So we sit in, but post-COVID situation, video conferencing, I think, is a thing that will have to come to stay, and it is possible if the arbitral tribunal, of course, all of us, in the sense, we are at that stage, not very articulate in technology. Some are, some are not. But during the course of this pandemic, some of us also have learned the technology, trying to open up files. When somebody bookmarks a file and said, I never heard of bookmarking. But now I heard what is bookmarking, how to open the file which is bookmarked. So these are things we have learned. So post this, I think this will come to stay. But even now things can move. But sometimes we have to understand the genuine problem that parties do face in pursuit of arbitrations.
Rajeshri, may I be permitted an intervention at this stage just for a second?
Absolutely, please.
You asked whether what happens if one party cannot have access to technology, or one party wants a physical hearing, the other party wants a virtual hearing, etc. I think we must move, particularly in the current situation where at different stages, at different places in the country, the lockdown is impacting people in different ways. There are various degrees of relaxation, etc. Perhaps we must move to what may become an ideal scenario where you have a hybrid system, where if a person wants to be physically present, he is welcome to be physically present. If a person wants to have a virtual thing, that party is entitled to have a virtual hearing. So a court or an arbitration panel ideally should have a system which offers a hybrid system. I mean, for example, I, like Justice Ribello and perhaps of the old school, I prefer to read and make my notes. I'm learning to annotate things on various virtual platforms, and I'm finding it very easy. At course of time, I will. But maybe at this stage, I'm a notes counsel, for example. So I make my notes. I like to refer to my notes. Somebody may be very conversant with the virtual world and may feel it's not necessary for him to travel to Mumbai from Delhi or from wherever, Agartala or whatever. So maybe we should evolve towards a system which offers a hybrid package in arbitration.
Very valid point, Freddie. And in fact, you preempted me. I was asking about the hybrid structure. But one question to both you and Justice Rebello. I mean, while this is all very nice to have a hybrid structure, can we possibly rule out that at a future point of time, the party who's on the losing side will go on Section 34 and say that I didn't get a chance, opportunity to present my case before the tribunal? Can that be ruled out?
No, as I pointed out earlier, Section 19 is the power conferred, is the power allowing the parties to agree to a procedure, or the parties don't agree to a procedure for the tribunal to decide the procedure. By most of our direction which we issue, what we call case management, when we issue the direct at the first meeting, the directions are issued with consent of the parties. So parties are very much a party to the schedule that is fixed up, the manner in which the proceedings are to move forward. And now, since the Supreme Court has recognized virtual hearing and has, except for cross-examination, I don't see any challenge available under Section 34 on the ground of this procedural requirement, or the failure, because procedure is something agreed by the parties, not agreed by the parties, the tribunal to decide. So I don't see any serious challenge under Section 34 to arbitration be decided by virtual hearings.
Sure. Nilanjan, Justice Rebello and Freddie both have referred to the witness cross-examination and evidence gathering process. Do you see that the parties may now be at least prepared to dispense with the cross-examination given certain issues associated with the remote hearing? What is your take on that?
I'm sorry, I didn't get the question very well.
The question was that do you see that parties may be ready now to dispense with the cross-examination given certain issues regarding remote hearing? So do you see that less of cross-examination happening?
Well, I mean, look, it's difficult to just give an answer to say yes or no, because again, it boils down to the fact that what did you agree at the stage when you decided to arbitrate, and which is where I come in, that most of the time, while 19.3 is there and we have power to decide, etc. But the question is, I must submit humbly that a lot of these then ultimately, get one of the problems with as a client and a recipient of the when you're doing this is that you always feel that this arbitration does not have a finality until it gets to the apex court. It will get challenged in these matters at and you do everything, you do 9, then you do 34, and so therefore you worry that if you were to if you don't have a very well laid out agreed cross examination, sometimes in a technical contract, if you and I'll go back to my own area or my business, that if you are looking at again a complex trade finance, a trade contract, or you're looking at a structured contract, if I'm not able to produce, do some of these cross examination, do some of these evidences, being able to produce, it is, I may have a lost battle. So I don't think, unless we've agreed that it's okay, given the facts of the case, we will agree to a particular method of and very upfront. So that's the thing, Rajshri. I mean, I don't think there is one answer that yes, we will be, clients would be agreeable or not agreeable. I again go back to the same thing. I think the way to go is that all of us, arbitrators, litigants, all of us have to move to a more organized institutional arbitration where the certainty of the process, the certainty of the rule, the certainty of the adoptability, what will apply to everybody has to come in. That is the way to go.
Sure. No, I take your point, Nilanjan. That's why I had earlier asked the question that do we see a trend towards institutional arbitration given all these problems that you referred to? But having said, let me turn once again to Justice Rebello and Freddie. We have seen in our experience, and this is in relation to witness examination, the parties have said that we need a 360-degree camera, need to ensure this protocol when the witness is in the room, and so on and so forth. Somebody said that, sorry, it is not possible because we cannot guarantee that the person is not in some way or the other. So to begin with, sir, what is your take on the examination in the virtual world?
No, beginning with, I will just like to add what last speaker spoke about. See, in the area of cross-examination, we are virtually in the field of contracts. So where there's many a time in these contractual disputes, evidence is not required. They can be disposed of by the documents on record itself. Recently, I was a party to an ICC arbitration where both the parties did not need any oral evidence. They relied on the documents alone, and the matter was argued based upon the documents alone. So therefore, it is not as if every arbitration requires cross-examination. Secondly, you learn from international arbitration that you are given a time frame for cross-examination. You are not allowed, as we do in India, that can go across 4 or 5 days of cross-examining a witness, when frankly speaking, most of the time those questions are totally irrelevant. But as I say, as arbitrator, we have some bias, that is not to stop cross-examination, fearing that a lawyer next tomorrow may not nominate me as an arbitrator. So otherwise, the cross-examination could have been cut short in so many matters. This is practically what we have learned over the last 10 years, which are handling matters. But coming to witnesses being away. You see, no, that is again a question where you have, if we have counsel who are willing to agree, it's again only in the context of those persons who want to defer the matter, that such objection as to whether somebody says demeanor of the witness is important. As if now, as of today, of course, years ago, demeanor was considered, but as you see, some witnesses speak the truth, some witnesses come not to speak the truth. This is what the moment you see the affidavit, the moment you see the first cross-examination, so therefore demeanor and all those things are really not relevant. It's maybe a rare case in the good old days where demeanor was relevant, but it's no longer. Of course, you know from what the witness, how the witness speaks, and the affidavit as to what has been deposed to. So these small procedural difficulties, I think, should really not stand in the way of proceeding with virtual arbitration.
Rashi, may I seek your indulgence for a quick comment? Sir, the only submission I had, what I was trying to say is that why it is difficult to respond, say that while yes, it is contractual. And I'll give you an example. If I have a handwriting expert, I need to bring in. If I have a signature mismatch, I need to verify. These are, and if one of the premise of this dispute is premised on such matters, I cannot then do away with the cross examination. So I'm saying, therefore, to react to what Raishu is asking, that I find it difficult to say that in all cases we will it will be there or not there, because it depends really on the facts of the case where you really need to depend on such matters. So that is what my only submission was, sir.
In fact, I think rather than cutting down the requests for examining witnesses, the opening up of the virtual world and arbitration to the virtual world may actually have the opposite effect, because parties may now be more readily willing to examine witnesses, let us say, who are in America or in England, and would otherwise have had to spend a great deal of time and money getting them here. Such parties will now have it far easier to procure such evidence for themselves by reason of the virtual world. So you may have more applications, for example, under Section 27, where they will say we want court assistance to get a witness and we'll examine him virtually. Earlier it used to be at the discretion of the court when you applied. It's not as if witnesses were not examined through video conferencing. As far back as in 2003, Justice Variava, sitting in the Supreme Court in that Praful Desai case, said and laid down various rules and said that yes, he was dealing with Section 273 of the Criminal Procedure Code, that if you had a video conferencing in cross-examination, then would you be examining the witness in the presence of the accused? And he came to the conclusion that yes, video conferencing means that you are examining the person in his presence. He, of course, laid down certain safeguards. He showed enormous foresight, because several years ago, and he laid down certain safeguards in a non-COVID situation with no lockdown. He said, let two people from the opposing party be present when the cross-examination is taking place. Last year, we did an arbitration in Delhi where we had to examine a witness who was in Hawaii, and there was nobody present. He was at some beach resort, he was in his shorts, and he came across on the video conferencing, and it went through very smoothly. I mean, there was no difficulty on the video conferencing, except that there has to be commonality of documents. That's about all. Otherwise, it becomes very cumbersome to cross-examine. So it's possible, and I in fact see an increase in people asking for allowing to be led evidence or cross-examination, because it facilitates it. This virtual world facilitates such a thing.
And sir, if I may say that also, because one of the difficulty comes in that you want to follow everything as the High Court rules have done to constitute what are the tenets of a cross-examination, because otherwise it's going to get challenged under 34 after you've done everything and spend lakhs of rupees to get to an arbitral award. So the trouble, sir, is that's what I was trying to say, that is where we get stuck. That is the only place where we need to relook at, sir.
So that is, see, in countries like England, or for the matter Singapore, Hong Kong, once an award is passed, those countries those courts of those countries rarely interfere with the award, which position unfortunately is not the position in India. Let me say, I have been a part of the system, but again, it's like an ad hoc system. Where one judge will look at it in one context, another judge will look at it from another context, and some will interfere, some would be really to interfere. Some would say, hands off, we shall not interfere because parties have chosen the arbitrators, arbitrators have decided, and therefore we shall not interfere, except in those situations contemplated by Section 34. But that is what happens in if that kind of approach our courts have, like what we have in London or for that matter in Singapore or Hong Kong, virtually then it will be more effective. But we still don't have that.
See that happening with the arbitration, more and more arbitration going online, and possibly we will move from ad hoc to institutional arbitrations, as Nilanjan was mentioning. There's a big chance. So do you see the role of courts diminishing?
No, as it is now by the Amendment Act, there are two parts of it. The first part is the constitution of the tribunal by appointing an arbitrator in the event parties don't agree. This is the first part. Now here also, when frank enough, when I was an arbitrator, when I was doing it in the early years, when the Act 1990, the Act came in, I had one afternoon in a week, and every application used to be disposed of. This was before Patel came in. Post Patel engineering, the whole scenario changed. Now, of course, Section 11(6)(a) has come in, where the challenge is confined only to existence of the arbitration agreement or under Section 8. But again, I am told Section 11(6)(a) they are seeking to drop. Whether it has been dropped, I do not know by the notification. So this is the first part. Then the second part is interference in the course of the arbitration. What unfortunately I find is, even if there is no remedy provided in the Act, courts have been interfering in the Article 227, 226, 227, sometimes 115, in areas where actually there ought not to be judicial review. This is another area which we are seeing. And the third area, of course, is in the matter of challenge to an award. Now, again, challenge to an award, it depends on the judge who is handling the matter. As I said, we have judges who will say hands off. Of course, there are other judges who would like to be free with, more generous with interfering in the award. And so we have this, when you use the word hybrid, I would use the word hybrid here also, the hybrid kind of judges. So therefore, it all depends. So therefore, the first part now should be much easier. The second part, courts by and large should not interfere with the system of arbitration that is going on. And the third part is, of course, is again, it's your luck to be before the judge concerned, whether he's a judge who will look at arbitration with the concept hands off, because these are, you have chosen your men, you know what you have chosen, you know their capacity, the capability, and only in those areas where you can interfere, you should interfere, otherwise hands off. This should be the test for every arbitral award. We can't hear you.
You're on mute, Rajshri.
I'm on mute? No, I'm not
Yeah,
on
Yeah,
mute.
Now we can hear you.
Okay, sorry. Freddie, your thoughts on this? Do you think the involvement of judiciary will come down, or it will?
I'm not going to. Justice Rebello has rightly commented on the existing situation not necessarily in a virtual world, but I assume that your question is directed as to whether, with arbitrations increasingly moving to a virtual platform, will that impact the court intervention? We
That's
use
right.
intervention in a very pejorative sense, as if every intervention by the court is an unnecessary intervention. But court interventions can also be very helpful. And as Justice Rebello rightly analyzed, there are various stages at which a court can intervene. In the initiation of the arbitration stage, in a Section 11, in a Section 9, an intervention by a court may be a very helpful intervention. It may actually sort of help the arbitration to get along, prod the arbitrator to do something. The problem arises in the matter of the conduct of the arbitration, the actual conduct of the arbitration. Pleadings, you reject some, just as a hypothetical, you reject some pleading because it's not filed in time, or something like that, people feel dissatisfied about the conduct of the arbitration. Now, there, I think in a virtual platform, questions may arise as to whether a party, one party had perfect technological equipment and could be heard very well. Another party was, let us say, in a remote area where there was a frequent breakdown and he was not able to present his case in the manner in which he wanted to. These are questions which will arise peculiar to a virtual platform or peculiar to a virtual world. And in some cases, I mean, in such cases, I think courts may be perhaps called upon to intervene if they feel that a party has actually not had a. Of course, one way of doing it is to say that you wait till the award and challenge it at the time of the award, like the Section 16 provision. But I think broadly, and so far as arbitrations are concerned, it may well be that if a party is handicapped by reason of some kind of a technological deficit, maybe not due to his own fault, I think arbitrators will generally have to be a little more understanding of the problem so that it is better that the party has a full opportunity or both parties have the fair opportunity, as Section 18 says. You have to treat both parties fairly, rather than to say that no, in interest of sort of finishing it off quickly, I'm going ahead, I'm steamrolling this party. Too bad if you have not had access to some technological equipment. Personally speaking, I think the arbitrator who sort of has a slightly more understanding position, maybe adjourn it for a day or two, maybe allow him to rectify whatever the defect is. If, for example, you had a difficulty in speaking there, or we had a difficulty in hearing you, I mean, if that happened in an arbitration and an arbitrator said, no, I'm irrespective, I don't need to hear you, I'm going ahead, it may well be that a court may have to interfere. And of course, at the 34 stage, as far as the difference between an existing physical world 34 and a virtual world 34, I mean, I really don't think there's much, that there can be much of a difference. It is, as Justice Rivera said, it's the approach of the learned judge. Some judges construe 34 very strictly, and most judges, in fact, now things are changing, where judges feel that no, we will not, the line of Supreme Court judgments, starting with associated builders, etc., have now tried to narrow down the scope. But I don't think it makes a difference, so much of a difference, whether it's a challenge to an award which is the outcome of a virtual hearing and a challenge to an award which is the outcome of a physical hearing. I don't think 34 impacts it to that great extent.
Sure. Quickly, before I move to the next part of the discussion, I wanted to ask you one question. It's kind of, we as practitioners of arbitration law, or be it as or counsels, this whole issue about venue arbitration has been a interesting topic. So, does that change now the whole understanding in the context of online arbitration? What is your thought on that?
Is that addressed to Justice Rivera?
Justice
Rivera
can take it, or you can also take it.
I didn't hear who it was addressed to.
Okay, I will just comment about it. If you open up section 20 of the Arbitration Act, the section 20, the place of arbitration or the place of sitting can be what can be agreed by the members of the tribunal or by the parties. But the seat of arbitration will be the seat of arbitration, whether virtual hearing or otherwise. The seat of arbitration will be the same, because the seat of arbitration defines the court where the challenges are going to be made, the court where you're going to apply for. But where you are going to sit, you can sit for convenience, you can sit everywhere, anywhere. And section, for example, you may have to go to see some evidence in Madras. And I was sitting in Madras when the seat of arbitration is Mumbai. The tribunal can do that. Tribunal, suppose this, we had a matter, for example, the seat of arbitration was Mangalore. But parties and counsel, but the members of tribunal and the parties agreed that they will be sitting in Bangalore instead of going all the way to Mangalore because of other difficulties. So therefore, I have done myself some matters pertaining to some other place by sitting in Mumbai. Parties agreeing, but then in the award we would mention that a seat of arbitration is so and so, so that challenge to that award will go to that court where the seat of arbitration is. So even you don't have to go to that place to pronounce the award, as long as you mention the seat of arbitration that place, and of course the stamp duty, whatever it is, will have to be on the place. So therefore, This difficulty is not there. Place of arbitration is something different. Seat of arbitration is something different. Place of arbitration, section 20. You can decide where you are going to sit for the sake of convenience.
Sure.
Personally, I think that the problem will arise only in cases where the seat is not specified. If the seat is specified, then irrespective of where you hold, as Justice Rubello rightly says, where you hold the hearing or which place you go to examine a witness is going to be an irrelevant consideration, because your seat of arbitration is either the agreed seat or the determined seat by the tribunal. What may pose a problem is when you have to determine what is the seat of arbitration in the absence of an agreed seat or a determined seat of arbitration. Then, of course, all these tests that, which is the place which is closest, which has the closest connection to the matter, or there may arise some problem. This latest judgment of the Supreme Court, or a couple of latest judgments, which now virtually equate place with seat in many cases. In that what is it, Soma BGS NHPC case, and the later one, which sort of seems to take a slightly different view on it. But therefore, the section 34 will pose no problem. What may, I mean, I don't know. It is a hypothetical question at the moment. But if you have three arbitrators, one sitting, let us say, in an arbitration where there is no seat which has been prescribed or no seat which has been agreed, and you have an arbitrator sitting in Mumbai, an arbitrator sitting, let us say, in Singapore, and a third arbitrator, let us say, sitting in Canberra, in Australia, then questions may arise as to which court will then have jurisdiction in the case of something which a party wants to, some relief that a party wants by approaching a court during the course of the arbitration, not at the end, not at the section 31st stage. Let's say at the end. Can you go to the Canberra court? Can you go to the Mumbai court? Which court will you go to? Something will have to be resolved. Maybe the most practical thing would be to say that you have to go only to the place where the presiding arbitrator sits, or where he is physically present. I don't know. I mean, this is something which is hypothetical, something which hasn't arisen, but it is likely to possibly crop up in some jurisdictions, or even in a domestic arbitration. If you have in Delhi, Mumbai, and Calcutta, I mean, which court would you go to during the course? Because that will also determine your section 42 jurisdiction.
Sure. But that's an interesting situation. I mean, we'll have to wait and see how it pans out. Let me turn to Nilanjan. And Nilanjan, I know you are quite keen on mediation as a form of ADR. So my question is, would you see mediation becoming more relevant in the next days, or not so? What's your thought?
And Rajesh, if I may just sort of also on the previous question about the interference, I think as one of the litigants, it becomes one of the issues. And I just want to make one observation there, if you may permit, is that look, while all of us need speed is important, but we still need interference when it's required. One of the reasons section 34 and interference of the court comes in is because I read in this one of the recent judgments of Justice Ramana, where it is said that it is because of muddled arbitration awards. It is he used the word muddled arbitration awards, which is devoid of what 31(3) says, that arbitrators should give clear reasons for arriving at a particular conclusion, and that sometimes is not there, and that is one of the reasons why this gets into arbitration. And if you may permit me, I think the wonderful one sentence which is there in the judgment, it says we need to be cognizant of the fact that arbitral awards should not be interfered with in a casual and cavalier manner unless the court comes to a conclusion that the perversity of the award goes to the root of the matter without the possibility of alternative interpretation. I think that is very key in the conversation which we were having previously, that is very key as to the responsibility on, it is really hinged on all of this, responsibility of the arbitral award being written properly, the court resisting, and so I think that is important for us, because as litigants we need finality, and otherwise it's no fun. Coming to the mediation, I think as an institution, as an ICICI Bank as an institution, we have been very sort of trying to promote also this mediation through an alternate dispute redressal through an online dispute redressal platform. So you in fact have even sponsored a and been a part of one of the LawTech challenges where there has been a platform created by an organization called Sama where you can actually sort of do the entire ADR process through an online methodology. Insofar as mediation is concerned, very quickly, I think, Rajshri, that there are, from a banking perspective, if I were to say, that there are two paths to it. If you really look at it, the lending part of our disputes, there, it may take a little bit of time, except for us to adopt mediation, because you are already going through. You're in a contentious situation. You're going through wanting to pay. We as bank saying that you've got to pay. Rounds of negotiation already happened about trying to come to a settlement. When that fails, then you get into trying to get into dispute resolution. There, I think it may not work in terms of mediation, but when there is a large number of litigation, which is what we call the service litigation, where you had some service related to the banks, or when it comes to not only banks, but it could be your any food service provider, any healthcare provider, where it is relating to service, where unless the one party decides to that they're hell bent to take the other party to the cleaners, it is possible to there is a great opportunity to actually do mediation and declog the courts. The courts' time today, the lower courts and all of the courts' time are being taken off, but there are a large number of litigations which are relating to the service litigations. So that we feel is a huge opportunity for helping the entire judicial system.
Sure. I think that's a very cogent reason why you prefer to understand why you prefer mediation, Nilanjan. I think we are running short of time now. We have already kind of exhausted the time. I have got precisely two more questions, one to Freddie and one to Justice Rebello. So Freddie, to you, what is your general thought about the future of arbitration? Are you very optimistic? You sounded optimistic to me. Sorry, you're again muted. Sorry, Freddie.
Sorry. Yes, I am very optimistic about arbitrations, because I believe there has been in India a sort of resurgence of an awareness that arbitration can be an effective alternate dispute resolution system. I know that people in the past have been disillusioned with the manner in which the system has worked, but I think there is a conscious attempt now to see if we can have a workable, an effective working system which should be on par with acceptable systems around the world. And I think as far as our physical facilities are concerned, I think they equate with the best in the world. I mean, we've been to arbitrations abroad, we've been to arbitrations here. In terms of the physical infrastructure, whether you call it our five-star hotels or whether you want to have it in some sort of a room where you can the infrastructure is available. I think our physical infrastructure is on par with the rest of the world. We have to get the system going, and I think this opportunity presented by this COVID-19, where people are now moving towards a virtual world, and he said eventually I see arbitrations by and large being conducted through this virtual world. I mean, I think, of course, I'm not saying that the days of physical arbitration are numbered, because I don't think you can substitute that totally. But I think increasingly arbitrations will, because the informality of an arbitration proceeding, or the ideal informality, very often it's more formal than a court. It shouldn't be, but the informality of an arbitration proceeding, to my mind, lends itself to a virtual world. And as I said, so long as everybody has all the equipment, all the necessary paperwork, digitalized, etc., I think this will be a very good way to facilitate arbitration. I don't see this hindering arbitrations in the future.
So that's very good to hear that you see that there's actually a lot of positives for arbitration community going forward. So with that, I'll turn Justice Rebello. Sir, Last word from you. Find all these experiences in the wake of COVID-19. Do you see any changes being made, any amendments being introduced to the Arbitration Act, or see a need for that?
You are slightly broken up. Could you reframe the question? It was broken up.
Okay. Let me. I was asking you, sir, with all the experience that we are gathering do online virtual arbitration, do you see the government introducing amendments to the Arbitration Act to facilitate process and to protect the interest of business community?
The act, the Unilateral Act, as I saw it as a threshold, was a complete code which was over a period of 20 years by experts in the world. But unfortunately, at the time of reinforcing the law, there were some people did tweak some language, and then of course courts did come in. But and there have been, and practically every 2 or 3 years there has been amendment coming. So as of today, insofar as dealing with the issues of the pandemic situation, I don't see much, considering that, as I pointed out, the provisions are there in the Act itself. So we don't have to have any amendment. The second part, insofar as the business world is concerned, these are contractual disputes. At the end of the day, these are all are contractual disputes which parties come to resolve before an arbitral tribunal. The system is that if you have an efficient tribunal which is in a position to set a timeline for the matter. See, beginning earlier there was no time limit. Then there was a time limit. Now the time limit has been extended. But I do believe that pleadings can be completed within 6 months. And if pleadings can be completed within 6 months, then within the next 12 to 18 months, depending upon the nature of the matter can be disposed of. So virtually, I do not foresee, and I do not think any amendments are required to the Act as it exists, because everything is there within the Act. The problems only are in the matter of hearing, and these are practical problems which will be seen in every matter. This is not something that you can say that as somebody pointed out, in one matter there may be a breakdown, in another matter it may be not possible. These are things which can't be contemplated by the Act. An amendment presupposes that there are deficiencies in the existing Act, and those deficiencies have to be met. Now, to my mind, there are no deficiencies in the Act to proceed with virtual arbitration. If there are no deficiencies in the Act to proceed with virtual arbitration, I do not see the need for any amendment. And I would rather prefer that the Act is not tampered so often. Tampering with an Act results in law getting changed overnight, decisions coming one after the other. Believe me, if you read the judgments on section 11.6, the first judgment came, it says you have to refer it only to the existence of the arbitration agreement. The next judgment came saying, no, the court has discretion. Then the third judge had to say, in Mayawati's matter, this discretion is not there, and therefore that judgment is no longer good law. Therefore, lesser the amendments and we proceed with the Act as it now stands, I think it is better for all of us, because section 34 has been now I think virtually the nature of the challenge to an award has been set out. And in fact, we have used fundamental policy of Indian law, which otherwise was a concept in internet to challenge international awards, which we have brought into our domestic arbitration. So as far as I am concerned, I would not prefer any further amendment, unless some situation arises which we are not seeing today, and that situation has to be covered. I think that is
Valuable.
what.
Sorry, kindly go ahead.
So these are my comments. That hands off. Don't bring in any further amendments unless some practical difficulties do arise in the which we come across.
Sure. I mean, less tinkering, the better it is. Thank you so much, sir, and thank you, Freddie. Thank you, Nilanjan. This was really engrossing. I think though there might be more questions from my side, but we are running out of time, and we have maybe a couple of questions to be taken. So I will now request my principal associate in our litigation team, Avinav Mukherjee, to go through the audience questions, and Avinav, you can direct them to the panel appropriate. Over to you, Avinav.
Certainly. A very good evening to the panelists. Uh, well, this question has been asked interestingly by one of the attendees, and it says it is asked as it is usually said that an arbitration clause in a contract excludes the purview of courts to adjudicate on the subject matter of an arbitration. Has this changed due to COVID-19 because the parties are adopting virtual method because of constraints but not choice? It is addressed to the panelists. Any one of you can choose to answer.
I don't think that the approach of the court would have changed in terms of intervention. We have discussed the question of the court intervention, and that intervention of courts can be helpful and need not always be disruptive, or need not always be sort of a step backward. And insofar as the virtual world is concerned, I think courts may step in only if there is some sort of a gross inequity or unequal treatment between the parties. I mean, if somebody, as I said, does not have access to the necessary equipment for the virtual world, whereas somebody does, maybe a court might be tempted to say that, look, this shocks my conscience, and therefore I will come in and try and rectify it. But otherwise, I don't see why a court should interfere any more than in a virtual world arbitration than it would in a physical world arbitration. So, I mean, speaking for myself, as far as Section 34 particularly is concerned, I don't anticipate that there are any special features which will sort of add to a court's power or a court's inclination to interfere in greater terms with an award which has been delivered post a virtual hearing.
Right, sir. Thank you. Thank you so much for your input, sir. Well, just as we have run short out of time, I would like to propose with a vote of thanks. Everyone, it is my privilege to have been asked to be on the occasion, and I, on behalf of the Kochhar Co team, as well as the entire team of U India Chamber, here together, and on my own behalf, extend a very hearty note of thanks to all the panelists as well as the attendees who have graced the webinar. I must mention my our deep sense of appreciation for Justice Rebello and Mr. Devetri to provide their insights on arbitration post-COVID and the difficulties faced with it. I must also mention our deep sense of appreciation to Mr. Sinha for sharing his expertise as an in-house counsel and to deal with issues relating to the arbitration as well as the alternate dispute resolution. I'm also thankful to Mr. Barat for sharing his thoughts in respect of the commercial apprehensions in the world post-COVID. With this, I extend our thanks to the EU India Chamber and the staff for the back-end support to organize this matter, and the same was extended to Ms. Kochhar's team as well. Well, as you know, and as an event like this cannot happen overnight, the wheels start rolling weeks ago. It requires a lot of planning and a bird's eye for details. We have been fortunate to have been backed by our team, which is very motivational and dedicated colleagues. Therefore, I cannot thank everyone enough for their involvement and their willingness to take on the completion of the tasks beyond their comfort zones. We thank you everyone for being with us on this evening. It has been a great pleasure.
Rebello and Nilanjan. Really privileged to hear all of you. Thank you. And thank you, Mr. Bharat, and thank you, Chambers.
Thank you. Thank you for inviting.
Thank you.
Thank you very much. Of
May we
the
leave?
Council of Chambers of Commerce. Thank you very much.
May we leave the meeting?
Yeah.
Yeah, thank you very much. I think we can sign off. Thank you.
Thank you.